Prince Harry has indeed arrived at the High Court in London at his case against the publisher of the Daily Mail.
Breaking news from the courtroom, and the fallout is brutal. Prince Harry's lawsuit didn't collapse under cross-examination or hostile judges.
Duke of Sussex has finished giving evidence in a privacy case against the publisher of the Daily Mail and Mail on Sunday.
It buckled under his own legal strategy. A claim meant to expose press wrongdoing instead reframed everyday journalism as criminal, triggering visible unease, stunned reactions, and quiet alarm on both sides. Was this overreach, a fatal misread of the law, or a desperate gamble gone wrong? Because the moment that argument landed, everything shifted, and the case may never recover. When the argument turned on itself. The moment Prince Harry's case truly began to unravel did not come from a hostile judge, an aggressive defense, or a sudden lack of evidence. It came from inside the courtroom, delivered calmly and confidently by his own legal team. In an effort to prove unlawful behavior by the press, they made a claim so sweeping that it quietly changed the direction of the entire case. They argued in open court that the basic mechanics of journalism, using sources and offering payment for information, amount to criminal conduct. And with that single assertion, the foundation of the lawsuit began to crack. This was not a dramatic outburst or a shocking revelation. It was presented as a matter of fact, almost routine, yet its implications were enormous. By framing ordinary journalistic practices as illegal, Harry's legal team did more than accuse the media of misconduct. They set a standard that, if taken seriously, would redefine how news has been gathered for decades. Suddenly, the case was no longer about whether Prince Harry was wronged by specific actions. It became a question of whether journalism itself, as it is widely practiced, could exist under the rules his lawyers were proposing. Inside the courtroom, this argument landed with a weight that may not have been fully appreciated at the time. Instead of narrowing the focus to clear, provable violations, the legal strategy expanded the claim so broadly that it became difficult to defend. If paying a source is unlawful, then where does that leave investigative reporting? Where does it leave whistleblowers, confidential informants, or industry insiders who routinely speak to journalists under similar arrangements? The case, meant to expose wrongdoing, now appeared to challenge the legitimacy of the profession it was accusing. What made this moment especially damaging was its timing. This was not a speculative argument floated on the sidelines. It was introduced as a central pillar of the case, shaping how evidence would be interpreted and how past events would be judged. From that point forward, every example presented to support Harry's claims would be measured against this rigid definition of illegality. And that definition left very little room for nuance, context, or reality. The shift was subtle but decisive. Observers expecting a clear narrative of misconduct instead found themselves listening to an argument that seemed disconnected from how media cases are normally fought. Rather than isolating specific acts and proving intent or harm, the legal team appeared to be attacking the very tools journalists use to do their jobs. In doing so, they unintentionally raised doubts about whether the case was grounded in law or driven by a misunderstanding of how information is actually gathered. This was the point at which the case stopped being a straightforward challenge to press behavior and started to feel like something else entirely. The focus moved away from Prince Harry's experiences and toward the logic of his own legal strategy. And once that happened, the question was no longer whether the press had crossed a line, but whether the case itself had just crossed one it could not come back from. So how did a strategy meant to expose wrongdoing end up exposing its own fatal flaw before the judge reacted? Keep watching. A standard that could never hold. Once that argument was placed on the record, the damage became unavoidable. By claiming that gathering information from a source and offering payment in the process automatically turns that information into something unlawful, Prince Harry's legal team locked the case into a position it could not realistically defend. What sounded, on the surface, like a firm stance against press misconduct, quickly revealed itself as a legal standard that simply cannot exist in the real world, especially in cases involving journalism. At its core, the claim was absolute. It left no room for context, intention, or established practice. According to this logic, the moment a journalist speaks to a source and money is mentioned, the line into illegality has already been crossed. That framing may seem powerful at first glance, but in a courtroom, power means nothing without precision. Laws are built on limits and definitions, not sweeping generalizations. And this was where the case began to weaken under its own weight. Journalism, particularly investigative journalism, does not operate in a vacuum. Sources come forward for many reasons, some moral, some personal, some practical. In many cases, payment is not a reward for wrongdoing but compensation for time, risk, or access. By ignoring this reality, the legal argument stripped itself of credibility. It suggested a version of media practice that does not match how news has ever been gathered, reported, or regulated. And courts do not rule based on how things should work in theory. They rule on how they actually work. The consequences of this position were immediate and severe. If paying a source is unlawful by default, then almost every major investigation in modern media history becomes suspect. That is not a narrow accusation, it is an impossible one. By setting such an extreme standard, Harry's legal team unintentionally shifted the burden of proof onto themselves. They were no longer required to show that specific actions crossed legal boundaries. Instead, they had to defend an argument that challenged the legitimacy of an entire profession. This is where the logic turned fatal. Courts are cautious by nature. They resist arguments that would cause widespread disruption unless the law clearly demands it. A claim that threatens to criminalize normal journalistic behavior does not invite sympathy. It invites scrutiny. And under scrutiny, this argument begins to collapse. If the standard cannot be applied consistently, it cannot be upheld at all. Rather than strengthening Harry's case, this approach hollowed it out. The focus drifted away from alleged wrongdoing and toward the feasibility of the legal theory itself. Each time the claim was repeated, it raised the same unanswered question. If this is illegal, why has it been accepted practice for generations? Without a convincing answer, the case lost its footing. By the time this logic settled into the proceedings, the damage was already done. The argument was no longer just controversial, it was unsustainable. And once a court begins to see a case as built on an unworkable premise, everything that follows is viewed through that lens, placing the entire legal challenge on increasingly fragile ground. Now, how did one legal argument meant to expose misconduct end up redefining journalism itself and quietly destroying Harry's entire case? Stay glued. The example that changed everything. As the case moved forward under this rigid and risky legal standard, one example rose above all others and became the centerpiece of Prince Harry's argument. It was not presented as a minor detail or supporting evidence. It was treated as proof. Again and again, attention returned to the same incident, the Chelsea-Davy flight saga, offered as a clear demonstration of how the press had allegedly crossed the line. But instead of strengthening the case, this example exposed its deepest weakness. At the heart of it was a single email. Heather Briley, identified as a journalist, contacted Caroline Graham with information relating to Prince Harry and Chelsea Davy. The message referred to flight details and described how the information was obtained. It mentioned contact with someone at British Airways, noting that this contact had been approached shortly before and that money had been offered in exchange for a name. According to Harry's legal team, this email was meant to show that the information had been gathered unlawfully. On paper, the email appeared straightforward. It described a journalist reaching out to a source, attempting to verify details, and pursuing confirmation through an industry contact. Yet this was precisely where the case took an unexpected turn. The legal team treated the contents of the email as a confession of wrongdoing, when in reality it read like a routine snapshot of how journalists chase leads. There was no evidence of hacking described, no coercion laid out, no illegal access detailed. What it showed was communication, inquiry, and sourcing. Despite this, the Chelsea Davy flight example was repeatedly leaned on as a cornerstone of the claim. Each time it was raised, it was framed as an obvious breach, something that should speak for itself. But the more closely it was examined, the more it seemed to say the opposite. The act of speaking to a contact at British Airways, asking questions, and even discussing payment did not, on its own, demonstrate illegality. It demonstrated the process. What made this moment so damaging was not just the choice of example, but the insistence on its interpretation. By holding this incident up as proof, the legal team effectively invited the court to examine it line by line. And in doing so, they highlighted how ordinary it was. The email did not reveal a secret operation or a shadowy scheme. It revealed a journalist doing what journalists have always done, seeking information from someone with access and attempting to confirm a story. Instead of exposing misconduct, the example began to undermine the argument it was meant to support. If this was the strongest illustration of unlawful behavior, then the standard being applied was far too broad. The court was no longer being asked to judge a specific act of wrongdoing, but to accept that common reporting methods were inherently illegal. That is a much harder case to make. As this example remained at the center of the discussion, the imbalance became impossible to ignore. The legal team kept pointing to it as evidence, while its contents quietly contradicted their claims. And with every reference to the Chelsea Davy flight email, the gap between accusation and reality widened, pushing the case further into uncertain territory. And when proof turned poisonous, how did Harry's strongest evidence morph into a shield for journalism instead inside the courtroom? Stay tuned. When proof became the problem. By the time the Chelsea Davy flight example had been examined closely, a striking pattern began to emerge. The case was not weakening because evidence was absent or incomplete. It was weakening because the evidence being presented was doing the opposite of what it was meant to do. Each document, each email, each carefully selected example was supposed to reveal misconduct. Instead, it was quietly revealing something else entirely: structure, method, and professional routine. This was the twist no one seemed prepared for. The legal team did not fail because they lacked material to present. They failed because they chose material that worked against their own argument. The Heather Briley email, intended to demonstrate unlawful behavior, ended up illustrating how journalists verify information, pursue leads, and confirm details before publication. Far from exposing chaos or abuse, it showed order. In court, intent matters just as much as action. The lawsuit was built on the idea that journalists had crossed clear legal boundaries, yet the evidence offered never quite reached that line. What it showed were conversations, follow-ups, and sourcing efforts that aligned with established reporting practices. There were no dramatic leaps, no secret break-ins, no undeniable signs of illegality. The problem was not what the documents hid, it was what they openly displayed. As this realization settled in, the entire case took on a different shape. What had once been framed as a fight against unethical journalism began to look like a challenge rooted in misunderstanding. The legal team appeared to be arguing against how journalism functions in reality, rather than how it should function in theory. And courts do not operate on theory alone. They operate on precedent, context, and common practice. This shift was subtle, but devastating. Each piece of evidence now carried unintended weight. Instead of supporting the claim that Prince Harry was the victim of unlawful intrusion, it raised questions about whether his legal team fully grasped the profession they were accusing. The more clearly the documents showed journalists following a process, contacting sources, confirming information, weighing details, the harder it became to label those actions as criminal. What made this especially damaging was the consistency of the pattern. It was not one isolated mistake or a single misinterpreted email. It was a series of examples that all pointed in the same direction. The evidence did not show recklessness. It showed a procedure. And procedure is difficult to condemn when it mirrors industry standards. The case began to feel inverted. Instead of exposing wrongdoing, it appeared to be documenting competence. That inversion changed how every argument was received. Claims that once sounded serious now carried an unintended irony. The legal team was effectively building a record that could be read as a defense of journalism rather than an indictment of it. As this realization grew harder to ignore, the lawsuit drifted further from its original purpose. The issue was no longer whether journalists behaved improperly, but whether the case itself was built on a flawed understanding of their work. And once that question enters the courtroom, it becomes impossible to separate the strength of the claim from the credibility of the strategy behind it. So how did a lawsuit meant to expose abuse transform into proof of journalism's integrity, and who misread the battlefield? The double standard no one could ignore. As the case continued to unfold, the pressure no longer came solely from the strength of the evidence or the logic of the argument. It began to come from inside the strategy itself. A quiet contradiction emerged, one that did not need dramatic language or pointed accusations to be damaging. It simply needed to be seen. On one hand, Prince Harry's legal team was asking the court to view paid journalistic sources as proof of unlawful behavior. On the other, they were relying on paid participants of their own to build and support the case. This was not a matter of opinion or interpretation. It was standard legal procedure. Witnesses are compensated, private investigators are hired, experts are paid for their time, knowledge, and analysis. None of this is unusual in a courtroom, yet that reality made the legal argument increasingly difficult to sustain. If payment automatically taints credibility or legality, then the same question must be asked of everyone involved in the case itself. The contradiction did not need to be spoken aloud to be felt. It hovered over the proceedings. The court was being asked to accept that journalists crossed a legal line simply by compensating sources, while simultaneously accepting that Harry's legal team could pay witnesses and investigators without that same suspicion applying. The two positions could not comfortably exist side by side. What made this tension so damaging was its simplicity. There was no complex legal loophole to explain it away. The principle being argued against the press was broad and unforgiving, yet it was not applied inward. That imbalance weakens credibility in any serious legal setting. Courts are built on consistency. When one rule appears to apply only in one direction, it invites doubt. This was not about accusing Harry's legal team of wrongdoing. It was about logic. Payment, in itself, is not proof of illegality. It is a mechanism. In journalism, it can mean compensating a source for time or access. In law, it can mean paying for testimony, investigation, or expertise. By condemning one while relying on the other, the argument began to fold in on itself. Under scrutiny, this inconsistency became impossible to ignore. If the legal team's definition were applied evenly, the case would undermine its own foundation. Witness testimony could be questioned. Investigative findings could be challenged. Expert opinions could be dismissed. No courtroom operates that way, and no judge could reasonably accept such a standard without destabilizing the process entirely. The deeper problem was not hypocrisy, but sustainability. A legal argument must survive examination from every angle, including those that point back at its own structure. This one could not. The moment the court recognized that payment alone does not equal impropriety in legal proceedings, it became harder to argue that it does so in journalism. As this realization settled in, the case grew more fragile. The focus shifted again, away from alleged misconduct and toward the internal coherence of the claim. The more attention paid to how the case was built, the more it became clear that the standard being proposed could not be upheld without dismantling the very system it depended on. And once that contradiction takes hold, it lingers, quietly eroding the strength of everything that follows. And as this realization settled in, did Harry's own strategy doom the case by attacking journalism itself instead of proving misconduct? Stay with us. Locked into the wrong position. By this stage, the weakness in the case was no longer abstract. It had taken on a clear shape, and it was rooted in strategy rather than personality. The issue was not who made the argument, but how firmly it was pressed, and how little room it left for retreat. At the center of this moment was David Sherborne, Prince Harry's lead counsel, and his repeated insistence that the emails at the heart of the case clearly referred to payment. That phrase, delivered with certainty, was meant to underline wrongdoing. Instead, it ended up reinforcing the very defense the case was trying to defeat. The problem was not that the emails mentioned payment. That fact was never in dispute. The problem was what that mention actually proved. By emphasizing payment as the defining feature, the argument stripped away context and replaced it with an assumption. It suggested that the mere presence of compensation was enough to establish illegality. But as the case had already begun to show, payment alone does not carry that weight, especially in journalism-related matters. What made this strategic misstep so damaging was its rigidity. There was no pause to reconsider how the evidence was being interpreted, no attempt to narrow the claim, no effort to reframe the argument once its implications became clear. Instead, the legal team doubled down. The emails were presented again as conclusive proof, as though repetition could turn an ordinary detail into a decisive legal violation. In doing so, the case became trapped by its own framing, by openly acknowledging that the emails referred to payment, and treating that as the smoking gun. Harry's legal team inadvertently made the defense's job easier. The defense did not need to dispute the facts. They only needed to explain them. Once payment was placed front and center, it invited a simple response. Payment is not illegal by default, and it never has been. This is where strategy matters more than intention. In complex cases, lawyers often leave themselves room to adjust, to respond to how evidence is received, to refine arguments as weaknesses emerge. That flexibility was missing here. The insistence on a single interpretation hardened the case into a shape that could not bend without breaking. Every time Sherborne returned to the same point, it narrowed the path forward. The argument no longer allowed for nuance or distinction. It did not differentiate between ethical breaches and routine practice. It did not separate questionable conduct from accepted norms. Everything was folded into one claim, and that claim rested on a premise the court had little reason to accept. What made this especially striking was how unnecessary it was. The case did not fail because there were no alternatives. It failed because none were explored. There was no recalibration when it became clear that the evidence was being read differently than intended. The strategy stayed fixed, even as its foundation weakened. By locking the case into this position, the legal team removed its own escape routes. Any attempt to soften the argument later would risk contradicting earlier statements. Any attempt to retreat would raise questions about consistency. The path forward had been chosen, and it led deeper into a logic that could not support the weight placed upon it. At that point, the case was no longer being tested only by the defense. It was being tested by its own structure. And once a legal argument reaches that stage, where its greatest obstacle is the position it has taken, every step forward becomes more precarious than the last. Now, by locking the case into this position, could Harry's own strategy now be the trap that finally destroys everything he's fought to prove? When the ground gives way beneath the case. By the time the strategy hardened and the arguments could no longer be adjusted, the consequences stretched far beyond a single disputed claim. What began as a focused challenge to press conduct now faced a much larger problem, one that threatened the entire framework of the lawsuit. The issue was no longer whether one email had been misread or one example overstated. It was whether the case, as constructed, could survive once the court recognized the evidence for what it actually showed. The danger lay in perception. Courts do not just weigh facts, they assess patterns. Once judges begin to see evidence as routine journalism rather than unlawful behavior, the lens through which everything else is viewed changes. Emails that once appeared suspicious start to look procedural. Contacts that were framed as improper begin to resemble ordinary sourcing. And once that shift occurs, it does not remain confined to one incident. It spreads. This is what makes the mistake so far-reaching. The argument advanced by Prince Harry's legal team was not narrow enough to fail quietly. It was broad, declarative, and foundational. It claimed that the presence of payment alone transformed journalism into illegality. When that claim weakens, it does not merely dent one part of the case. It undermines the logic holding the entire structure together. At that point, the lawsuit faces a cascading problem. If the Chelsea Davy flight example does not prove wrongdoing, then what standard is being applied to the rest of the evidence? If contacting a source at British Airways and discussing payment is normal practice, how many other claims rest on the same assumption? The court cannot ignore that inconsistency. Once it recognizes that the benchmark itself is flawed, every supporting argument must be reevaluated. This is where legal momentum quietly reverses. The case no longer moves forward on the strength of its accusations. It becomes defensive, forced to explain why ordinary actions should be treated as extraordinary violations. That is a difficult position for any lawsuit, especially one that seeks to challenge an entire industry's practices. What makes this moment particularly precarious is that the evidence has already been presented. The emails are on the record. The arguments have been stated clearly. There is no unseen document waiting to change the narrative. The court now has enough material to form an opinion about how the case has been framed. And once that opinion takes shape, it influences how every subsequent claim is received. The broader implication is impossible to avoid. If the court accepts that the examples presented amount to normal journalism, then the lawsuit begins to look less like a necessary challenge and more like a misinterpretation of professional conduct. That does not mean concerns about privacy or press behavior disappear. It means this particular case may not be the vehicle to address them. As the foundation weakens, the burden shifts. Instead of the press having to defend its methods, Harry's legal team must justify why those methods should be treated as unlawful here and nowhere else. That is a heavy lift, especially when the same principles do not apply cleanly to the legal system itself. Consistency matters, and once it is questioned, credibility follows. The exposure is subtle but significant. The case is no longer shielded by the assumption that wrongdoing is obvious. It is open to interpretation, skepticism, and legal doubt. Each new argument must now clear a higher bar, because the court has already seen how evidence can be framed in a way that overreaches. At this stage, the legal fight does not collapse with a single ruling or dramatic dismissal. It erodes. It becomes harder to explain, harder to defend, and harder to justify as the correct avenue for the claims being made. And as that erosion continues, the question hovering over the proceedings grows louder. If the strongest evidence reflects standard journalistic practice, what remains of the case once that realization fully sets in? So, what do you think happens when a lawsuit meant to expose wrongdoing ends up proving normal journalism instead? Does the entire case quietly collapse from within? Or is there a twist still waiting to surface? We'd love to hear your thoughts in the comments. Don't forget to like, share, and subscribe.